Good evening. Looks like we have a good house here tonight. Can everybody hear me in the back? Well, I saw nodding. So, I'm Dennis Kennedy. I direct Peace and Conflict Studies, and on behalf of PECON and the McFarland Center for Religion, Ethics, and Culture, I welcome you to tonight's event. Our speaker tonight is Tricia Bushnell. Her lectures and titles you can see behind me: Race, Poverty, and the Criminal Justice System, Lessons Learned from Wrongful Conviction Cases. Tricia comes to us from Kansas City, where she was kind enough to inform me that it's much colder there than here. So good of her to come out here. She directs the Midwest Innocence Project out there. She serves on the executive committee for the National Innocence Network. She also serves as president of the ACLU of Missouri. Previously, Tricia worked as a clinical faculty at the Wisconsin Innocence Project at University of Wisconsin-Madison. She was also a fellow at the Equal Justice Initiative of Alabama, where she represented indigent clients sentenced to death, juveniles sentenced to life without parole, and sexual offenders challenging the collateral consequences of their convictions. Before that, Tricia earned her JD from NYU School of Law and her BA from Bucknell University, where we met 17 years ago. And even then, I can report that Tricia was an impressive individual. Still remember learning about German critical theory from her and thinking that she was one of the smartest people that I'd met. And she still is one of the most intelligent and committed people that I know. So it's a real personal pleasure to introduce her today, in addition to the amazing work that she's doing. I hope you'll join me in welcoming Tricia Bushnell to Holy Cross.
Thank you, everyone, for being here today. Can you hear me well with this? So I appreciate the opportunity to come here and speak with you a little bit about the work that I do and the work of the criminal justice system in general. I have had the experience over the last decade getting to see the best and the worst moments of the criminal justice system. And I want to come and talk to you a little bit about it today. But to start off with, I want to give you some framework about why this is so important to me and why I think it should be important to you. So the first picture I want to start with here today is Mr. Liddell Lee. Liddell Lee was executed last March of 2017 in Arkansas, when Arkansas decided that they were going to execute 8 individuals in 10 days. Mr. Lee never once met his trial attorney. He was convicted in front of a judge who was having a romantic relationship with the prosecutor that they never disclosed. The judge wrote in his opinion that he hoped there was no way that anyone could ever investigate this case. On appeal, when he had an attorney who finally realized that the judge was having an affair with the prosecutor, that attorney showed up drunk to court, such that the judge ordered him to have a breathalyzer and a drug test run. Despite the fact that he had no adequate counsel, nothing was ever presented for Mr. Lee. Fast forward, 20 years later, they schedule his execution date. The Innocence Project steps in. We represent him and say, we believe DNA testing could prove his innocence. There was hair and other forensic evidence that could be found, and the court denied that stay. Mr. Lee was executed without ever knowing what the evidence could show us. How can that happen? How can we have a system that says we are for justice for everyone, that we will provide you an attorney, and we provide what we did for Mr. Lee? That's the background I want you to be thinking about when I talk to you about what we see in the criminal justice system today and why we do the work that we do. So I'm going to take you to another story. This is Emmanuel Gissendanner. I want to talk about how I got into the work, because what I'm hoping is that there are many of you, like myself, are sitting here very skeptical. When I started, over 10 years ago, my first innocence case was 12 years ago, I had come from prosecutors' offices, worked in prosecutors' offices. I believed in a system that rectifies our mistakes. And to that degree, I still believe in that system because I work in it every single day. But I didn't think that I was going to go and be a defense attorney. I didn't think I was going to do anything in the criminal system at all. In fact, I grew up in California. I'm the first in my family to go to college. My family's from Mexico. So I wanted to do immigration law. And so it's no surprising that I met Dennis because we were doing international law studies as undergrads. So I go to law school and I take a clinic, and I'm representing individuals who are undocumented immigrants who aren't getting paid by their employers. I loved it. And for those of you who are considering law school, a clinic is kind of like a residency for a doctor, but for lawyers. So we represented real people in the cases that they had in front of them. Well, At the time that I was in law school, there was a professor named Brian Stevenson, and I'm sure many of you have heard of him. He has a book called Just Mercy, and I believe he's come and spoken here at this center before. And he gave a very inspirational speech, and I hope you go and listen to it. It's a TED Talk now. And I thought to myself, I have the opportunity to work with this individual. Why won't I do that? So at that time, he had a clinic for us to go down to Alabama and represent folks who were sentenced to death. So I spent the last semester of my law school in Montgomery, Alabama, actually Dothan, Alabama, working on the case of Mr. Emmanuel Gissendaner, who's who you see here right here. So in the death penalty context, there are two parts of a case. The first part is what's called the guilt phase. Did the person do it? Okay? The second part is what's called the penalty phase. Are we going to sentence this person to death at the hands of the state, or are we going to sentence them to die in prison with life without parole? Those are the only two options if you were charged with a capital crime. So when we look at a case on appeal, we are wondering, were there errors on the guilt phase, like saying that they didn't do it, or was there error in the penalty phase? And what we're saying is jurors really should have found they should have been sentenced to life without parole. So I get down to Alabama, I get assigned my very first case, Mr. Emmanuel Gissendaner, and these are the facts. Mr. Gissendaner was convicted of murdering an elderly woman, Miss Snellgrove, who was found, her body covered in the woods near his home. She'd been murdered in the carport of her home, so there's blood everywhere. She'd been blunt force trauma to the head. Someone had hit her over the head with a rock. Mr. Gissendaner is seen driving her car all over town. Picks up a bunch of friends, drops them off. He goes to the bank and passes a check from her bank account to his name, signs it, puts his thumbprint on it. There is a speck of his blood on her sock. Bad facts, right? I look at this case as a young law student and I say to myself, guilt phase is done, we're going to be working on the penalty phase, right? How are we going to get him life without parole? But what I realized, and one of the first many lessons that I've learned about the criminal justice system, is we actually need to listen to people. We need to assume wisdom in what they are saying us and trust them, but verify it. So Mr. Gissendaner tells us that he's innocent, and we're sort of like, yeah, well, there's some really bad facts, but we investigate. And this is what we uncovered. Mr. Gissendaner in high school was a very, very talented football player. He'd actually received a scholarship to play football at the University of Alabama, but his girlfriend got pregnant, so he stayed home. There's no opportunity for him in rural Alabama, so he begins selling weed on the side of the highway. And that's what he's doing one day when a man named Buster Carr drives up in the car and says, I want to pawn my car to you for drugs. This is actually quite a common practice, both in rural areas and in cities, where individuals who don't have cars that have drugs will say, yeah, I'll give you drugs, in exchange I get to use your car, basically leasing the car for drugs. So that's what he's doing. It's a hot day. Mr. Gissendaner is ecstatic to have a car, which he never has, and he's got his socks in the back of his pocket. He pulls the sock out and he wipes what he thinks is a bit of dirt off the back of the bumper. And I don't know if y'all have been down to Alabama, but the dirt there is red. It is blood red. It is called Redstone Arsenal for a reason, but you can only know that if you've been down there. So the speck of blood that ends up on his sock ends up only on the heel of his sock. One tiny speck, which would be inconsistent with somebody who would have murdered the victim and where blood ends up all over the carport. So he's driving the car around, super ecstatic, and like I said, picking up everybody from town, driving them here, driving them there, when he keeps driving and the car breaks down. So the car breaks down and he goes and he finds Buster and he says, hey man, I'm so sorry. I was driving the car and it broke down. What do you want me to do? And Buster says, take this check, go to the bank, cash it, and use the money to get the car out and the rest for what I owe you for the drugs. So that's what Mr. Gissendaner does. No one had bothered to investigate this. What they also failed to find, because they didn't investigate, was the victim, Ms. Snellgrove's body was covered with tree branches. Those tree branches were about as thick as my wrist and professionally cut. What that means is that he could not have just done this with something that was found in his car. And instead, Buster Carr, the person he got the car from, was a tree trimmer who had been working on Ms. Snellgrove's house the morning that she was murdered. What they also didn't uncover was that Buster's brother, who provided an alibi for him, had been paid by the state to provide that alibi. They went to him, they paid his rent, they paid his utilities in exchange for him changing his testimony from what was in the original police reports. What the state also didn't disclose was that they had had the handwriting on the check analyzed, and that they knew that the handwriting on the signature line was different from the handwriting in the rest of the check, and only the signature line was consistent with Mr. Gissendaner. So here I am looking at this case that I thought was hopeless, that I had prejudged, when I had never challenged my own assumptions, and the person that was supposed to be representing Mr. Gissendaner didn't do it either. So fast forward, that would have been 2006. I leave law school and I go to a big law firm in Los Angeles, and they let me take Mr. Gissendaner's case with me. In 2010, I've moved back to Alabama. I'm at the Equal Justice Initiative, and we win him a new trial in front of the very judge who sentenced him to death, who says, not only do I find his trial was unfair, he had ineffective counsel, the state withheld evidence, and I believe he is actually innocent. In 2013, I had moved to Kansas City. It was December. I was at the holiday party when I got notice that the Alabama Court of Criminal Appeals had overturned that and reinstated his conviction. He is still on death row to this day. We have yet to receive a decision from the Alabama Supreme Court, so here it is 11 years later, and everything that we know about Mr. Gissendaner means we are still waiting for justice. So how does that happen? And here's the boring part of the lecture. For those of you who are interested in going to law school, I am going to give you an entire criminal procedure class in about 5 minutes. Okay? So this is what you need to know. This is the life of a criminal case. This is what allows things that I hope are shocking you to occur. So the life of a criminal case starts here in the trial court. This is what you see on TV, right? Law and Order, CSI. This is where if you do not have an attorney, one will be appointed to you, right? So you have an attorney. They're standing here with you, and hopefully they are objecting to everything, right? I always tell young law students, if you don't know what to object to, just say the entire Constitution. Put in all the amendments. Object. And the reason for that is when you lose here, and I'm going to use male pronouns throughout the entirety of my talk because the vast majority of our clients are men. When Mr. Client loses here in the trial court, he goes up to the Court of Appeals. And you'll see in my example, I've given Missouri Supreme Court, but every state has its own courts or courts of appeals. So on this Court of Appeals, he's still represented by an attorney. The state is still providing one. But now what this court is going to review here is only the things from box 1 that attorney jumped up and down about. So if your attorney did not object to something that was unfair, too bad, so sad, we're not going to hear it. Okay? Only those things which he puts in there will be reviewed. What that means is things that this attorney doesn't know and doesn't put in will not be reviewed. New evidence cannot be reviewed. The misconduct of the state cannot be reviewed because you don't know it yet, right? They can only review what is in that trial transcript. So in our clients' cases, we lose here, we lose there. You can ask the U.S. Supreme Court to hear it. They probably won't. They take about 1% to 2% of all cases, and that's your entire direct appeal. Process takes about a year to 18 months. Okay? Why that's important is because the next appeal you have is what's called your post-conviction or your state habeas. So here, you've lost, and now you no longer have a right to an attorney. Okay? You are now by yourself, incarcerated, with no funds and no investigator. And this is what you have to do. You have to go back to the judge, who maybe sentenced you to death, but certainly found you guilty, and you have to say, Your Honor, I have new evidence, and if you heard this evidence, you would either find that my trial was unfair or that I was innocent. And those are the only things you can present. Anything that is new. So what's new? Bad lawyering. You couldn't have known that your trial lawyer at the first trial was terrible because you don't have another person to tell you. And that he couldn't object and say, Your Honor, objection, I'm terrible, right? And they were going to review that on the thing. So that's something new if they did something egregious. In the case of my client, Ricky Kidd, out of Kansas City, Missouri. So Ricky was convicted of a double homicide that occurred in broad daylight. At the time of the homicide, he was in the sheriff's department getting a gun permit. Good alibi. Trial counsel failed to present it. So, cannot allege ineffective assistance of counsel there because trial counsel is still representing him. So here we go. We put it all in here and we say, hey, if you'd known that, you would have found that he was not guilty. In addition to that, you get to bring in the state misconduct. So in the case of Emmanuel Gissendaner, the fact that they had withheld these checks and the analysis of these checks, the fact that they were paying the witness, we couldn't have known that before, so that's brand new. And my other favorite thing that most people don't know about or think about is juror misconduct. Jurors do crazy things. And I hope that you will all go serve on juries someday and remember this talk, not go do a crazy thing, but really take it very seriously. But jurors I've had cases where jurors have performed their own experiments to see if the evidence would happen the way they think it would. You can't do that. You can only make your decision based on the evidence in front of you. I've had jurors who go and visited the crime scene, who talk to witnesses. All these things you're not allowed to do. So we raise that here, and we say, Judge, if you'd known these new things, you would find me not guilty. Now here's the kicker. By yourself, no attorney, no investigator, right? And you have a deadline. In most states, you have 1 to 3 years from when this happens to get to here. So while you're in this appeal, you're looking at what, 18 months? So now how much time do you have to get over here? Not much. In many states, it ends up being somewhere between 90 and 120 days. If you miss your deadline, too bad, so sad, we're not going to hear it. I have a client, Lisa Harris, in the state of Missouri. She was been convicted when she was 17 years old. She missed her filing deadline by 1 day. Because of that, the state has never heard her claim. All right? So you finish this, you go up to the Missouri Supreme Court, or you're here in Massachusetts, the Commonwealth, and you go through and you ask the United States Supreme Court, not going to hear it, so you get your last chance. Your last chance is to go to the federal habeas court. So these are all state courts. Now you're going to the federal court. In the federal court, you're only allowed to raise all the stuff that was raised here. So let's think about Ricky Kidd. Ricky Kidd, his attorney didn't put on his evidence of his alibi, right? Also didn't put on the evidence of the real perpetrators who did the crime, who were seen driving the rental car that left, who went and bought duct tape that was used in the crime, all these things. Doesn't put that in. So Ricky, by himself, files his post-conviction motion. And he alleges 12 claims. Of those 12, he has ineffective assistance of counsel. My attorney was bad. And he says, my attorney was bad for not putting on my alibi evidence, right? And my attorney was bad for not putting on the evidence who really committed the crime. So what happens? The court appointed an attorney for him, and that attorney promptly dismissed 9 of the 12 claims. So now, when he's going up through here, they're only looking at 3. Are any of those 3 the alibi claims? No. Are any of those 3 the claims about who really committed the crime? No. So now when he comes to his federal habeas district court, they say, oh, well, too bad, so sad. You abandoned all of it. We're not going to hear it. You didn't take it all the way through. You have to take your claims all the way through for the federal court to hear it. And to get from this box 2 to 7, all has to take place in the course of a year. Confused yet? I hope so, because this is what the vast majority, this is what every prisoner is undergoing when they're working on their appeals. There are 3 areas of law that are considered to be the most complicated in the United States: taxes, immigration, and habeas. And this is what we tell people you have to do on your own with no counsel in order to get yourself out. So here's the crazy part. When we're talking about your federal habeas, what we are talking about are your constitutional rights, right? You guys know your constitutional rights? First Amendment, freedom of speech, right? Fourth Amendment, freedom of search and seizure. Those constitutional rights are what they're looking at. Were those violated? The U.S. Supreme Court has never said you have a right to be free if you are innocent. Think about that. What that means is if you can prove you are actually innocent, that is not enough to get you out of prison. What does that mean? So the U.S. Supreme Court says we haven't made that decision yet in a case called Herrera versus Collins. But what they have said in a case that came out of Missouri called Schlupp versus Delo is, all right, if you can prove to me that you are actually innocent, I will let you back into court. I will ignore the fact that you missed your deadline or you already had an appeal or somebody abandoned it. I will overcome all of these mother may I rules that I use to keep you out of court to let you in. But in order to get out, you must have a constitutional claim, all right? And I think about this back in 2014 when Troy Davis was executed in Atlanta, Georgia. So Troy Davis was convicted based on the number of witnesses who testified that he had committed the crime. Over the years, every single one of those witnesses recanted. And in his majority opinion, denying a stay of execution for him, Justice Scalia wrote, "You do not have a right not to be executed if you are innocent. You have a right to process." And Mr. Davis had due process. So these are the parameters under which incarcerated Americans are working every single day. Before you are convicted, you are presumed innocent. But when 95% of our cases end in pleas, you give up that shroud of innocence, right? So now you are working in a process that values finality over fairness. Can we be done with this over whether or not this was fair? And that is what we can see when we look at cases like Troy Davis. So this is Ricky Kidd, as I mentioned. So in Ricky Kidd's case, we thought we had that Schloop actual innocence claim back here to get in the federal court. So we solved the crime. 3 perpetrators committed this crime in Kansas City. They showed up, broad daylight, walked into a home, and shot and killed 2 men. Tied one up with duct tape, shot him in the back of the head, shot the other man in the middle of the street at 2 o'clock on a Saturday. Everyone saw it. There was a 4-year-old little girl, Kayla Bryant, who was left surviving in the home. They pick up Ricky, and they charge Ricky and another man named Marcus Merrill. Marcus Merrill had come from Atlanta with 2 other individuals. They're called the Goodspeeds, Goodspeed Sr. and Goodspeed Jr. They alibied themselves together. They were together the entire time. They stayed at the same hotel. They drove the same rental car that was seen leaving the crime scene. They stopped and purchased duct tape on their way, which was shown to do that. And Marcus Merrill says, come forward since their conviction, and says, I did it with these 2 other individuals. And corroborating that, there is another new witness that we discovered, who Marcus Merrill and the Goodspeeds went to get their guns. One of the guns that they provided was a revolver that fell apart in your hands. So when Goodspeed Jr. was trying to shoot one of the individuals, it fell apart and rolled across the floor, and that's why the man was able to make it outside in broad daylight. So once these 2 individuals, once they committed the 2 murders, Goodspeed Sr. orders Marcus Merrill to go in and kill the 4-year-old girl who's left behind. Marcus Merrill gets inside, he sees her, he has a 4-year-old of his own, so he shoots a bullet into the kitchen wall and puts her in the closet. That bullet matches the calibration of the guns that were given to them by the witness the night before. All new things, right, that were never presented at Ricky Kidd's trial. All things that we say would show that Ricky Kidd is actually innocent. Unfortunately, when they had his federal habeas appeal, the circuit that we are in the country, it's called the 8th Circuit, it's a federal district, is the only one that says in order to be new evidence of actual innocence, right, the new evidence you need to get and overcome these procedural bars, to get into court, in order to be new, it could not have been available to your attorney at the time of trial. So what does that mean? That means if all the evidence of your innocence existed at the time you were convicted, and you had a terrible attorney like Ricky Kidd did, and nobody presented it, it can never be enough to get you out of prison. And that's what happened. Ricky Kidd, we litigated this case in 2013, is still incarcerated. He's been in 25 years. And even though the judge who heard the case said, man, I hope those Goodspeeds don't get away with it, it seems like he had terrible counsel. Said they could not reach him to give him relief because of those procedural issues that I showed you in the chart. It was not about whether or not Ricky Kidd is innocent. It is about whether or not they followed the rules in being timely. So we thought that changed in the state of Missouri, and we thought that changed with Joe Amrine, who's here on the right. He's here with his lawyer, Sean O'Brien, on the left. Sean O'Brien also represented Mr. Schloop when I've talked about that actual innocence standard, Schloop v. Delo. So the federal courts say innocence, not a reason to let you out of prison, right? Well, in Missouri, we thought that we changed that. And we thought that that happened with Joe Amrine. Because what happened in Joe's case, Joe was convicted of a prison murder. Actually, the most Shawshank Redemption thing you'll ever hear, if any of you have seen it. He was convicted of a prison murder, and he was framed because they were running a prostitution ring out of the prison. So Joe is in another room playing poker when the crime occurs, and 5 witnesses come forward and say he did it. Every year a witness recants, and every year Joe files another appeal. And every year they say, you already had an appeal. It's too late. Doesn't matter. Until now, all 5 witnesses have recanted. So if you think about it, if I wanted to even charge him, if I even wanted to just bring an arrest warrant, I wouldn't have anything. There'd be no evidence. So in Joe's case, the Supreme Court, Missouri Supreme Court said, you know what? Innocence is enough, and ordered his release based on actual innocence. And we thought maybe the federal system, the U.S. Supreme Court, isn't going to recognize it, but the state of Missouri is going to. The Shawshank Redemption part about this is Joe then filed a civil lawsuit against the individuals who had charged him, and as the federal officers were walking up to the sheriff's home to arrest him, he took a revolver and killed himself. And with that went Joe's entire civil claim, so he has never received a dollar for the extra 16 years he served on death row. So, we think there's an innocence claim in Missouri. Well, fast forward to Rodney Lincoln. Rodney Lincoln was convicted in 1982. To give you some perspective, he went in the month before I was born. So for 35 years, he's been waiting for justice. He was convicted of a horrible crime involving the murder of a mother and assault on 2 young children. The 2 young children survived, and they said a man named Bill did it. Bill came from Hollywood. He drove a white Volkswagen. He worked on Mom's car. But then going forward, they can't find anyone named Bill that matches their description. They're showing her dozens and dozens of pictures. This poor young woman, she's 7 years old. She's having surgery after surgery. She has a colostomy bag until someone says, we think that, she says it looks kind of like their cousin Gary. So they draw a composite sketch of Gary. They're looking at now this composite sketch of Gary, who is not the real perpetrator. And they say that kind of looks like a guy that the mother used to date named Rodney. So they come back in now to her, and the detective says to her, I need you to look through a magic door. And behind this door is the bad man. And if you don't pick the bad man, he's going to go free. And then he shows her just 2 pictures, one of Rodney Lincoln and one of her cousin Dennis Smith. She picks Rodney Lincoln. They arrest him. He has his first trial. It results in a hung jury. He has an alibi for that the entire time. He was at work. He was with his mother. He was with his then fiance. And so they go to a second trial. At the second trial, they present a hair that they found in the crime scene that they said matched him when they compared it under a microscope. This could be a whole different lecture, but suffice it to say that is not real science. That exceeds the bounds of science. The FBI has conducted its own review of every case it's ever done and found a 93% error rate in the testimony they provided about microscopic hair comparisons. You cannot say that. I can say this hair could not have come from you. I cannot say this hair must have come from you. So fast forward to 2010, we do DNA testing. We go into court and we say, this is not his hair. There was also a hair found on the 4-year-old victim. He is excluded from that as well. And we say, let Rodney go free. And they said, nope. The court says the young victim who identified him has never wavered. And so they find that his conviction stands. Fast forward to 2015. Oh, I'm missing a picture. Fast forward to 2015, and that victim recants. As a 41-year-old grown woman, she says, I was pressured to make that identification. We received new documents that show that they coached her extensively, that they had her sit on the stand, practice what she was going to say, and she says it's not him. So now we think, hey, this is just like Joe Amrine's case, right? Joe Amrine, don't have any evidence left, couldn't charge him. Rodney Lincoln, no evidence left, couldn't charge him. So we go back to the court and we say, just like Joe Amrine, you need to let Rodney Lincoln out. And the court says, Mr. Lincoln mistakenly presumes that because he is innocent, he is entitled to relief. We have only held that innocence is enough if you are sentenced to death, and Mr. Lincoln is not sentenced to death. So that was in 2016, and this is where we are now. Mr. Lincoln is now 73 years old. He has emphysema, and we are stuck in a system that says, we don't care that you're innocent. We can't touch it. So that leads me to the real question of what is justice? And that is the number one thing that I think we think about in this role. What is justice? What does it mean for us? What does it mean for our clients? And who decides it? So I think about that when I think about the case of LaQuanda Jacobs, Faye Jacobs right here. Faye is my client, one of my clients. She's in Arkansas. She was 15 years old when she was sentenced to life without parole. And I don't know if you know this, but we don't sentence kids to die in prison anymore for crimes they commit at that age. The U.S. Supreme Court has said We do not do that as a mandatory sentence because kids are not irredeemable. Kids grow, they change, their brains are not yet fully developed. So we want to look at this and say, what is happening? So in Faye's case, she was convicted of a shooting that happens on the street. 2 people get out of a car, they hold up 2 young men walking down the street for a starter jacket. All of you are way too young to remember what those are. But they're dressed in all black. The surviving victim says the woman was dressed in all black, appears to be in her late 30s, and has pockmarks under her eyes. 2 hours later, they arrest Faye Jacobs in her white church dress from where she has been all morning. She's 15 years old. They charged her with another individual who they later dismiss all the charges against because they have no evidence, and they convict her of capital murder. At the time of her trial, her defense attorneys, her first defense attorney tried to get her to lie and say something about another informant who was in the jail with her. She gets a second defense attorney who, at the time that happened, his wife was murdered by a different client, and he'd become an alcoholic. So she never has an attorney who represents her at trial, and she has no appeal. So what does this mean? In Arkansas, it's in that district where I have to have new evidence. So I've solved Faye's case. I know who committed the crime. But all of it was available at the time of trial, right? So it's not new. So I can't raise it in court. But she's entitled to a new sentence under the U.S. Supreme Court that says we don't sentence kids to die in prison. At her sentencing hearing, we get to present evidence of her role in the crime, right? And we feel very adamantly that we can present that she played no role in the crime. But what is the best scenario for her? Time served. So in Faye's case, the best form of justice we can get for her is time served after 23 years of incarceration. She will come out a felon. She will come out with no ability to get a job. She'll have never lived on her own, have never gone shopping for groceries, never paid a bill in her life, even though she's in her 40s. And that is the best that we as advocates can find as justice for Faye. And what is justice in the case of the West Memphis 3? Some of you may remember this case. It's out of Arkansas. You can watch a movie about it. But essentially, Damian Eccles, who's on the right, is sentenced to death, and the other 2 co-defendants are sentenced to life in prison without parole for a crime they did not commit. Their conviction gets overturned, and the prosecutor goes back to them and says, we will only not recharge you, we will only not take you back to court if all 3 of you take a plea. If you don't, all 3 of you take a plea, we're going to make you go to trial again. And if you go to trial again, Damian risks ending up back on death row. So all 3 of them took that plea. They are not considered exonerated. Even though the evidence of their innocence was enough to overturn their conviction, they are not exonerated. And that is what justice looks like for them. So the title of this talk is about race, poverty, and criminal justice, and we haven't gotten into that very much. So I want to get to it just a little more quickly. So this is the data that we know of exonerees by race. And as you can see, even though African Americans make up somewhere between 12 to 15% of our entire population, they make up the vast majority of exonerees. If you add in Hispanics and Latinos, you're looking at 60% of all of our exonerees are people of color. So why does that happen? Why does it happen that the people we are exonerating are people of color? How did they get to be there in the first place? And I think the first thing we want to think about not only is what is justice, but who decides justice. And if you leave anything with anything today, I hope it is this. Know your prosecutor. Know your prosecutor. The vast majority of prosecutors in the United States are white men. 79%. 1% are women of color. Why does that matter? Well, let's look at who's deciding death penalty cases in the United States. This is the percent of prosecutors who are white in death penalty states. You will see if we have the death penalty, the prosecutors are almost exclusively white. Let's take it a step further. If you actually go after the death penalty, the prosecutors are all exclusively white. 98% of all prosecutors who seek death are white. 1% is black, 1% is Hispanic. The vast majority of people who end up on death row, over 75%, African Americans. So who is deciding what is justice for other individuals and folks of color, right? You look at plea offers of what we have here. This is what people get offered. So these white prosecutors come up to a white defendant, and more time for white defendants, they offer them community service or a fine or time served than they do for African Americans. For African Americans, they offer them jail. That is it. That is your plea. So even when we are saying, I'm going to take you to a plea, I'm going to take you to jail, right? You can find out here in Massachusetts who is deciding justice in terms of your judges. Well, you only have about 10% of your judges in Massachusetts are people of color. 34% are women. Not great. When we're deciding what justice means, what we're essentially saying is, what does justice mean to an elected white male? And I want to talk about why this matters. This matters because when prosecutors of color are elected, innocent people go home. I know that's a bold statement, but the numbers bear it out. You can look to Brooklyn, to Kem Thompson, who was the first African American to be elected a prosecutor in Brooklyn, and he has freed over 14 individuals. You can go down to Dallas, Texas, where the first African American in the entire state of Texas was elected, and he has freed dozens of people. And the reality is, when the prosecutor wants someone to come home, they come home. Mr. Gissendaner, who you talked about right at the beginning, right? Had his case for 12 years. What if the prosecutor decided they didn't want to fight it anymore? That would be decades of his life back. But that's not where we're at. And to give you the greatest example about why this matters is I want to talk to you about the case that is changing me forever. I know I've talked about a lot of cases, but this one is big. Wyandotte County in Kansas City, Kansas. Kansas City's on the border of Missouri and Kansas, right? So Kansas City, Kansas is a small part. It is the very first stop for freedom on the Underground Railroad. If you get to Quindaro, you have reached freedom. Missouri was supposed to be the last slave state. Missouri compromise, right? And then folks decided, oh, maybe not so much, and they invaded Kansas to try to make Kansas a slave state. That's actually the history of the Jayhawks and the Tigers, if you're ever interested in sports. So here, in Kansas City, Kansas, the place that should be freedom, for 35 years, a detective named Detective Roger Golubsky has been raping and sexually abusing poor black women with no repercussions. And we know this not because someone decided to start listening to poor black women, but because he used that power to wrongfully convict my client, Lamont McIntyre. So Lamont was convicted when he was 17 years old, and he was convicted because Roger Golubsky had been sexually abusing his mother. His mother, Rosie, said no more. She moved. She changed her phone number back in the 90s and tried to get away from him. When a murder comes up, a double homicide, again, right in the broad daylight, where the victim's family members see it happen, the detective gets a call that he needs to be taken care of. He goes down to the police station and he makes a lineup with 5 photos in it. Every single individual in those photos was a family member of Rosie McIntyre. None of them were present at the time of this crime. It did not matter who he got. He wanted to get someone related to Rosie. So 17-year-old Lamont McIntyre gets picked up. He gets put into jail. He gets put into prison. And what happens next? Well, the witnesses come forward at the trial, and they go to this prosecutor, a woman named Tara Moorhead, and they say to her, that's not the guy. That is not the guy who killed my brother. This is not the guy who killed my cousin. And the prosecutor says to them, you're going to testify that that is him, or I'm going to take away your children and charge you with contempt. So these young African-American women are now re-victimized and forced not only to know that the real perpetrator, the individual who killed their loved one, is out free, but they have to put another innocent person behind bars. And they do it. They get on the stand. They say Lamont did it. That prosecutor never tells the defense attorney. That prosecutor had also been having a romantic relationship with the judge that none of them disclosed to either party. So 23 years is how long it took to get Lamont McIntyre out of prison. It took 8 years of investigation to uncover enough evidence to show why Detective Golubski had been doing what he did. We have talked to over 100 women who have been abused by this detective. We get ready to go to trial, and we file. And we file, and the very first African American prosecutor in the entire state of Kansas got elected. We think maybe we're going to get somewhere. He wants to hear the evidence. He's meeting with our witnesses. And then he says, no, we're taking it to trial. We have 90 witnesses on our witness list. I don't know how much of you know about the law. That's a lot. It's a lot of witnesses. We got 90 people signed up to come to court. We're having a 7-day evidentiary hearing. Everyone's there. And we're about to put Rosie McIntyre on the stand. She's just started. We go to lunch break. And after the lunch break, the prosecutor says, I need some time. And I'm getting angry. I'm like, what do you mean you need time? We don't have time to get 90 witnesses on here. We're running out of time. But after the lunch break, he comes back and he says, just move to admit all of your evidence. So we move to admit all of our evidence. And he stands up and says, it is a manifest injustice that Lamont McIntyre is here today. Everything that has happened to him is a denial of his constitutional rights. And as a prosecutor, I am the minister of justice. I do not serve to get convictions. I serve to get justice. And Lamont McIntyre walked out of prison that day. It's October 13th, 2018. But if that prosecutor had not joined us, he would still be in prison right now. And I say that even if the judge wanted to decide for us. Assuming that the judge had even issued a decision by now, which I promise you he would not. He would probably be issuing a decision sometime in May. If the state wanted to appeal that, how many more years is that? Mr. Gissendaner can tell you it could be over a decade, right? Prosecutors decide justice. They are your ministers of justice. So who do you elect? And remember this, they are elected. They are your officials. And what that means, not only do they wield an incredible amount of power about who gets charged, who gets the entire power of the state on them, they get to decide what becomes law. So, in terms of wrongful convictions, we know how not to do eyewitness identification procedures anymore. Eyewitness identification procedures are 70% of all wrongful convictions are because the witness pointed out the wrong person. Y'all think your memory's great? It's not great, right? It's really not good in terms of cross-racial identifications or, and this is my favorite, cross-age identification. It is true. All you youngins look alike to us and we all look old to you. So what we know is how to make these procedures better, right? And it costs nothing. We just have people look at them one at a time. I give you an instruction that the person may not be in there. I make sure that everyone who's in there actually looks like the description that you gave. And then if I'm the one giving you the lineup, I'm not going to know who's the suspect. Easy. Easy peasy stuff. We cannot get this passed in Missouri because the prosecutors have killed it. Every single time. In Kansas, law enforcement joined us, said, that's great, we'd love to be part of that. But in Missouri, the elected officials out of St. Louis, many of you may know about some crazy things happening out of St. Louis, have said no. And that's the thing. Think about if your legislature, your representative, does something you don't like. You can call them. You can send them an email. You can write a letter. You can say, you do not represent me when you do this. I want you to do that. How do you do that with your prosecutor? They are your elected officials, and you should hold them accountable. Because I promise you, if that had been happening for the last 35 years, Lamont McIntyre and over 100 women would not still be waiting for justice. And if you want the sad, tragic remedy from Lamont's case, Roger Golubski's partner of 30 years is the current chief of police. So, we look at who decides justice, right? And we also look at jurors. Another fun fact, even though the cities where I live are 50% African American, the juries still end up exactly like this. White jurors, right? And if you had just one person of color to a jury pool, the conviction rate actually goes down, which is a fascinating statistic, from 81% to 71% for people of color, and it actually goes up for white folks of 66% to 73%. So what does that mean? Why is it that people of color don't serve on juries? This is why. So there's a case called Batson versus Kentucky. This is Foster v. Chapman, but you can look at it, you can Google it. When you are selected for a jury, both sides get to strike people that say they couldn't follow the law. Like, oh, I know the defendant, I'd be biased. You're relieved, you're dismissed, right? I could never convict somebody of a drug charge, you're dismissed. You're saying you couldn't follow the law. But at the end, when we get down to the final pool, both sides just get to strike people willy-nilly. Just get rid of who you don't want. And you don't have to give a reason. You don't have to give a reason unless you say that the other side is striking all African Americans or all people of color, all Latinos, whatever you want to say. And the reason for that is because it is violating the right of the juror. It's not actually violating the right of the defendant. It's of the juror who has a civil right to serve on the jury, right? So what you find is in cases like Foster v. Chapman is they go through and they write little notes to themselves. Oh, look, this is the prosecutor's notes. Black person, and they start striking everyone. We've had cases that use a lot worse language than that, but they went through and struck all the African Americans. And then when they ask for a reason, they have to give a race-neutral reason. And what you'll hear are things like, well, they appeared to be of low intelligence. They looked at me funny. I thought that they would be sympathetic to the defendant. Those are the bad reasons they can give, because then we come up on appeal and we've proved that that person they thought of low intelligence was actually a professor, and they could have just asked them some questions, and that's just what's called that's just a pretextual reason. It's a made-up reason. So in Foster versus Chapman, they're doing all of these things, and they give good reasons. They say things like, well, I didn't want any nurses on there, or he was retired, I didn't want someone who was retired on there. Those seem race neutral, right? But they're not race neutral when they're using them just to strike African Americans or people of color. And that's the issue of why part of the reasons why our jurors end up white. Because how do you prove the reason that they want them off is because they're black? What we've found is since Batson existed, since this case came forward, Batson versus Kentucky, prosecutors, and I say this, former prosecutor myself, prosecutors have come forward with trainings of how to get around the law. How do you give a reason that is a race-neutral reason so that your jury ends up white and you get your 81% conviction rate and not with your potential person of color, which lowers it? Right? So what about the public defenders? How do they help? Well, I can tell you in the case of Ricky Kidd, they don't help at all. My clients have lawyers who are just as biased as anyone else. We are all biased. Everyone. And I think back to Emmanuel Gissendanner. I've mentioned my family's from Mexico. I'm a person of color myself. I would not have understood that Emmanuel was leasing a car for drugs if I had not gone down to Alabama and learned about it myself. I just wouldn't have gotten it. That cultural competency was not there for me. And what we see time and time again is public defenders don't have it either. They spend less time on their clients of color, and they believe them less. Ricky Kidd tells his attorney, I was at the sheriff's department getting a gun permit, and nobody goes and talks to the people issuing the gun permit. Prior to getting the gun permit, he had returned his sister's car where she worked in a business office that had cameras in it. Nobody went and got that camera footage because they just decided already that what he was saying wasn't true. So, in terms of what are the biggest lessons that we can learn about how race and poverty work in the criminal justice system, it is this. We get out what we put into it. It is a human system, right? We have human prosecutors, so you need to know your human prosecutor. We have human decision makers, judges, juries, so you need to know who comprises those elements. But importantly, we know that that is a system that is going to make mistakes. So the biggest thing that I think we can do as the criminal justice system, and I hope that many of you go out and become prosecutors for this reason, is be able to acknowledge our mistakes. Because it shouldn't take 23 years of fighting to get Lamont McIntyre home. Ricky Kidd shouldn't be sitting there. Rodney Lincoln shouldn't be sitting there when we know they are innocent because somebody wants to fight about it. These were mistakes. People made mistakes for a variety of reasons. Missouri is the most underfunded public defender system in the country, currently being sued by the ACLU. People are going to make mistakes, but why can't we admit them? There has not been one case out of the state of Missouri or Nebraska in that time where they have admitted their mistake and let somebody come home free. But when we elect prosecutors, as soon as Mark Dupree was elected prosecutor in Kansas City, Kansas, that changed. So I hope all of you can leave from here today and think about that. What is the voice that you can raise to make that difference and change these numbers? Who decides what is justice? The answer is actually all of you. It's just who are you going to pick? I think we have time for questions after that. Great. So in terms of Detective Golubski, when we filed originally, he was at a different police department. He then retired from that police department with honors, and he is now the chief of security at Providence Medical Center, which is the hospital in the jurisdiction where low-income folks go to get treated. There's currently been nothing that's happened. The police department has declined to investigate, which is probably appropriate given the fact that the partner is serving on it. But at this time, no one else, the FBI, no one else has taken up that charge. So the question is, how do you get to choose your prosecutor, and do people who are going through the system get that ability? And the answer is the people who are being charged have no control over that whatsoever, at all, period. So if you're being charged, that elected official appoints whoever it is in their office that's going to charge you. And it's interesting. So we are living in a time now where people are being elected on smart justice campaigns. And so you're thinking about who's running for office. Philadelphia just elected the first former civil rights attorney as a prosecutor that I know. He was actually a civil rights attorney out of St. Louis, and he's now the prosecutor in Philadelphia. He came to be the prosecutor because people who were touched by the criminal justice system did what's called a Smart on Justice campaign. They went and they knocked on doors for the ACLU of Pennsylvania and said, here's been my experience with the criminal justice system. Here's what smart justice reform looks like. Do you support a prosecutor who supports smart justice reform? And that changed the entire conversation. And so now he has been elected and can do different things. I mean, they make the decisions about whether or not drug charges are prosecuted in your jurisdiction, right? But the reality is nobody knows they're running. Here's another fun fact. When a prosecutor's term is ending, so they're an elected official like anybody else, it's something like 80% of them, when they're done, choose their successor by retiring a year earlier and appointing someone who then gets to run as an incumbent in the next election. So you aren't even getting a fair, free slate of people when it comes up, and you don't even know all of the power that they wield. It's an incredibly important position. Well, there will always be a demand for attorneys. The question is, what does the sector look like for attorneys, particularly? I think you're asking a little bit about public interest law. There will always be a demand for attorneys because, first of all y'all need help for some reason at some point. And I say this to law students because I think they forget. We are a service profession. People come to us because they have a crisis that they cannot solve. I don't care what it is. I don't care if it's a family law issue, if you're going through a divorce, if you have a wills, trust, or estate. Somebody is coming to you because something sucks in their life. Nobody's ever been like, I'm really excited to go talk to my lawyer today. Nobody. So in that regard, there will always be a need for us. The question is, what service and what realm do you want? I would love to work myself out of a job someday. I mean, there's all these reforms that we know. We could restart recording things, changing eyewitness identification measures. But the reality is that's not going to happen. But what's the funding for it? So we are funded in our organization entirely by donations. The state doesn't really like to pay for you when you sue them all the time, right? And that's what I point out when you look at those 9 boxes. We only provide an attorney really for boxes 1 and 2. Out of your entire appellate procedure, we're only giving you an attorney then. Why? Because it's expensive. And if you think about it, the other big thing, if you really want criminal justice reform, is tell people to stop taking pleas. If people stop taking pleas, the entire criminal justice system would shut down. Period. You would not have enough lawyers to represent the state. You wouldn't have enough lawyers to represent the defendants. There wouldn't be enough judges. The judges are always going on about how busy they are. So what would happen? We'd have to charge fewer people, like drastically fewer people. And And so thinking about who's going to make those decisions, it's your prosecutor. Well, I would like to think we have realized that these inequalities and injustices aren't mistakes. I mean, I think, I can't speak for everyone, but obviously from my perspective, we created a system based on the fact that all people weren't equal. Like the entirety, I mean, we say all people are equal except for we can own some of them, right? Like that's in the entire premise of it. And you guys can watch the documentary 13th. I joke about it because I love that documentary, but it was basically my entire race, poverty, and criminal justice class in 2 hours. And it was like, oh, what was I doing? Was I even teaching? Just watch this documentary. But it talks about how we really started to say, oh yeah, we'll pretend everyone's equal, but by doing that, we'll just shift it to incarcerating people, right? It is a systemic problem. The question is then, how do you address those systems? And I don't know the answer to that. One of the questions I get a lot is the federal habeas review, right? You have a year to get from that box down to the other box, 3 to 7. And you have to raise everything in between. That was signed into law in 1996 by President Clinton. It's the Anti-Terrorism and Effective Death Penalty Act. It's a terrible law, right? So I've had legislatures ask me, well, should we change it? On the one hand, I would love to change it. On the other hand, do I trust the current systems to change it for better? And those are the questions that we ask ourselves. So that is why when I'm pushing for people to know they're prosecutors, this is the first set of person that you can know and approach, right? That actually is not necessarily a whole system, but somebody who represents a big part of it that you can change. Yes, well, and then this is where I backtrack on my own argument about how it's not a systemic problem. Because it is a systemic problem, and the systemic problem is how do you get people of color into law school and to graduate from law school, right? So I'm Latina. We make up less than 2% of all lawyers. We are not 2% of the population, right? So how do you get people of color into law school, through law school, and then knowing that systemically people of color have been oppressed and now have taken on all this debt into jobs where they can afford the education that they just had? And we haven't created that system. So when you think about things like the economic advantages, when you think about student debt relief, those are critical, important parts to getting people into those positions. And I'm in a privileged place. One of the only reasons I've been able to do public interest law for 10 years is I had a law school that paid my student loans. If you were in public interest, my law school said, we'll pay your student loans. That's amazing, right? Otherwise, I wouldn't have been able to even afford it. It wouldn't have been an option. So then how do you get that people to be your prosecutor to be there? First thing is turnout, though. You're right. Nobody votes for a prosecutor. I mean, how many people in here even knew your prosecutor was elected until maybe 10 minutes ago, right? One of the interesting cultural questions when you talk about cultural things is how other cultures handle issues of wrongful convictions. And the answer is it's different because the United States has an adversarial system. So I'm a prosecutor and I'm fighting with the defense attorney and one of us is going to win, right? Other systems have what's called an inquisitorial system where the judge actually really directs the investigation. It's really fascinating. And they're like, judge is like, I would like to send an investigator out to go find this evidence. And then they're really at the search for working together what really happened. So there have been suggestions, not yet proven, that there are lower wrongful conviction rates there. But it's just an interesting point about how our culture of I would say one of our cultural issues is our inability to admit we made a mistake. If we could admit we made a mistake, I think a lot more people would be home right now. Biased against and then charged to a higher degree, right? And two parts to that. One is I want to talk a little bit about a wrongful conviction versus innocence, which I neglected to talk about before. But overcharging someone is a wrongful conviction. If you overcharge someone with charges beyond what they have done, they are wrongfully convicted. And it's interesting because I would argue, my project does not represent people like that. We only represent people who are actually innocent. But I would argue they are innocent of some of those charges that they have, right? So that is what is happening when you're talking about these children who are acting out and then being overcharged about what they've done. And I say this with this as being an issue in my personal life. I have an African American child, and we have this issue where we're constantly talking about why is he being sent home when this other kid just did this other thing, right? And so what we're discovering is the ACLU, I'm president of the ACLU Missouri, works extensively in the school to prison pipeline area. So that's the number one thing that I could say, is to reach out to them and reach out to advocates to learn about things called IEPs, all these different things they have to provide. But what the studies are showing is actually, it's not necessarily the first incident, it's the later incidents. So if two children, a white child and a child of color, have behavioral issues in school, over time, the child of colors will get worse and worse and worse exponentially. So the first time, they're probably both punished the same. The second time, the African American students will go up significantly higher. The third time, even higher. It'll make these bigger, bigger, bigger jumps. And it's exactly what you're saying. So then they end up incarcerated, and we start a whole vicious cycle now of the cost, right, also of being a family member of someone who's incarcerated. So my organization works in 5 states. I neglected to say those 5 states. It's Missouri, Arkansas, Kansas, Nebraska, and Iowa. In Nebraska, they recently took to task the cost of jail phone calls. So jail phone calls are insanely expensive. It's like a huge thorn in my side. We take every call from an inmate, so they're all collect, right? So we pay a lot of money from every call. They're also not supposed to be monitored because they're calling us on their lawyer line, even though we have to pay. You have to pay to talk to your lawyer, right? So in Nebraska, they said, we don't want to have charges anymore on jailhouse phone calls. We want people to be able to call their family for free, right? And what they found was, there's a representative there, Ernie Chambers. You should look it up. He's amazing. Ernie Chambers pointed out that the money that they use from the jailhouse phone calls goes to pay for mandatory programming they are required to provide. So in essence, what the jail is doing is saying, the state told me I have to provide this for you, so I'm going to make you pay for it. Right? And that's what they do. And it's a crazy, crazy system that is driven in by large ways by people who don't think about people as people. I always wonder how many people actually go visit the prisons that they're selling something about, or governing, or documenting. I would venture not a lot. Well, first, win the lottery and be in a jurisdiction that has a great public defender system. There are some, right? Like go to DC, the public defender system there is amazing. But that's your first thing, right? Go back in time, get a new mom and a dad, and be born in a better place. But the biggest thing is I think of it like medical care. You have to be your own advocate when you go get medical care. We all trust doctors. There comes a point for many of us, I think, in our life where you're like, oh, wait, maybe I should ask my doctor why they're making this decision because I'm doing this, I feel this other way. And you have to be your own advocate. And that's what happens in the legal premise as well. So Ricky Kidd was his own advocate, drove his lawyer nuts. She wrote all these letters that were like, I am not taking any more calls from you or your family, which violates all these ethical rules. You cannot do that. She said, I'm tired of your phone calls. I'm not doing this. I'm not doing that, right? But he was out there actively trying to collect the evidence. And the worst part is, by trying to collect his own alibi evidence, the state then says he's concocting his alibi, right? Because his lawyer's not getting it. He's out there getting it. So being your own advocate, having family members that will be advocates, but that's the reality is every single person up there has a loved one who's gone to bat for them for decades, long before I got there. And I think it points out why we end up with so many people in the system who are also disadvantaged with intellectual disabilities and mental health issues. Because how can they be their own advocate, right? When Faye Jacobs was 15 years old and picked up, how's she supposed to tell her lawyer what to do? Most adults can't tell their lawyer what to do. And she has to write her own appeal then, right, without a lawyer when she's 17. So.
And my second question is, any advice for potential jurors?
I love jurors. And everyone I know right now has been serving on a jury. And then I'm so sad that I will never be able to serve on a jury. First of all, don't say that you know me or went to any of my talks. But, I mean, the biggest thing is to really be skeptical. And this is what I find fascinating, right? There are myths about people working in innocence organizations, one of which is we believe anything. We just believe everyone's innocent. I don't believe everyone is innocent. I've proven a lot of people guilty, actually, and closed those cases very quietly. But I am skeptical of everything. And that is what a juror should be as well, skeptical, but of everything. And what we find when we do juror interviews is almost unanimously jurors say, well, he wouldn't have been there if he hadn't done something. And people come away with this feeling of, there was other evidence that I wasn't allowed to hear, and if I'd heard it, I would have found them guilty. Which is a human thing, but we have to reject that. Like, no, what do we have in front of us right now? And I've also had at least 4 cases where I went and talked to them, the jurors, and they'll say, well, he was high on whatever. And I was like, there was no evidence of drug use in this case anywhere, but they've made up this story because it fits the rest of the pieces. So be skeptical, and then stand up when other people aren't. There was a recent grand jury, I want to say out of Philadelphia, maybe everything's happening out of Philadelphia right now, a recent grand jury where a defense attorney was put, so the grand jury decides charges, right? They decide whether or not to bring charges. And a defense attorney was made the foreman of a grand jury, and they decided unanimously as a grand jury not to charge any drug cases. That's amazing. I mean, and they have the power to do that. And so what I always think for jurors is, you have the power. It's scary. There's a judge up there. There's some lawyers yelling. But you are the decision maker. And no one else gets to force that out of you. Like, it is a very strong weight. And to just hold that with you while you serve. And thank you. I hope you get called. So the question is, why do you have to be proven innocent at some point? Through the steps. So the reason that you would have to prove innocence is to get in anymore. There comes a point when they're like, we don't let you into the system. So the saying, people hear this a lot, people got out on a technicality, right? People do not get out on technicalities. Technicalities keep people from getting into court. So the innocence is what overcomes all of those technicalities. And that's what's crazy. So I have a client in Arkansas right now where someone else has confessed to the crime and said they did it. I put him on the stand. He did all of these things, DNA testing shows it's him, all of this stuff. Somebody else had confessed earlier, falsely confessed. And we found out the state had put all of these people into prison with that person, threatened him with the death penalty, and recorded it and never gave it to anybody. So we didn't know why this guy was confessing, right? That is a constitutional violation. We go in, we're in here, we got these constitutional violations, we're showing his innocence. The court said, I find that that is a constitutional violation. You can't do that. But I don't believe you've proven innocence. And since you haven't proven innocence, I can't reach your constitutional violation because you're out of time. That's why. I know, it's backwards. It's like, don't think about it too much or your head will hurt. But that's the reality. We live in this world. Innocence is not enough. So if that's not enough, what kind of system do we want to make where we can think that things are fair? And with that, I think that was our last question.